Hi guys, it's Kathy. I hope you're doing well. I should have took off work this morning, but I'm here. Allergic reaction, taking meds. It's fine. It's fine. I think I narrowed it down to what it could be that is doing this to me. So, yeah, Bren, you can't see any of Granny's comments. Granny, you can't see any of Bren's comments. That's just the way it is. I don't know why. YouTube is YouTube is YouTube. But I'm gonna try to read chat, but I can't see. So if you say something and I don't respond, either I don't like you or I can't freaking see. You can pick whichever one you want to believe. Bobby, it's good to see you. Has anybody? Did Kelly talk to anybody yet? Since her surgery, is Kelly doing okay? Anybody know? I have to open up Discord to check, but it'll shut my computer down, so I can't right now. All right. We're going to the adorable judge today, and we're going to stay with the adorable judge all day. Okay, that's what our stream's going to be. We have the first case. He's not going to give us a decision on. He is going to give us a decision on the second two, but not the first one. And I don't know what he's going to say about the first case. I think I know. I mean, I'm pretty sure I know, but I could be wrong. I don't know. We'll discuss it. Probably pause the video and talk a whole bunch. You will hear something about the lawyer. Alright, the lady on the right is pro se. Okay? The lady on the left is a lawyer for an insurance company. I can't remember which one. Oh my gosh, Bren. You're a judge. All you do all day is judge and chat. No, I'm just kidding. Alright. So, but the lady on the left, the lawyer, I mean, it's shocking what we're about to find out, but it's not too shocking. You'll see. I'm going to tell you halfway through. I'm going to spoil it. Halfway through, I'm going to spoil it for you. Because I'm going to have to.
Vehicle and repaired said vehicle. A settlement check for diminished value was issued for $778.59 to Miss Federation in August 2025. In September 2025, she cashed the settlement check. Miss Federation is now advising the settlement payment was not enough, as to date, she has not provided any valid supporting documentation as to why the payment was not enough. Furthermore, denied our independent appraiser access to the vehicle for reassessment of her claim. Diminished value is not based on personal opinion or dissatisfaction. It must be supported by Miss Federation showing this court what the actual loss in market value of the vehicle is before the accident and after the repairs were made. In this case, the evidence will show that a settlement check Your Honor, a settlement check reflecting the calculated diminished value was issued in August 2025, and the plaintiff accepted that settlement payment, satisfying her claim. At the conclusion of this case, I will ask the court to find no additional diminished value is owed to her under the acceptance of cashing the check. Thank you, Your Honor.
Thank you, ma'am. All right, Ms. Federation, I'm going to go ahead and swear you in. That way, everything that you say going forward is testimony, and then that way you can present any exhibits and all that kind of stuff.
Okay.
Okay. The person sitting beside her is her husband. And I just think they make a great team. He absolutely supports her in every way she needs to be supported during this hearing. It's really, really well. You're really going to like it.
One thing I ever ask is if you're going to present something to me, you allow the other attorney to look at it and see if she has any sort of objection before she does so. And then you'll want to give any documents to the officer because he's going to get jumpy if you don't, and you start moving to the bench.
No problem.
Okay.
I won't get up.
Okay, perfect.
Bobby, I just want to say they were all really, really worried. I was not. I knew you were sleeping. But they were all very worried about you.
Will you raise your right hand for me, please? Do you swear in affirm the testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Perfect. You may go ahead.
Okay, so I can continue to read my
Continue on
opening
with
statement.
All of your evidence.
Okay.
Anything that you want to tell me.
Okay, at the time I told you about the value of the car. Early in the claim, when repairs were still approximately $6,000, Allstate issued a diminished value payment of $787.59. Acknowledging diminished value existed, Exhibit O. As repairs progressed, the damage expanded significantly. The final repair totally reached approximately $21,000 in repair.
Objection, Your Honor. She has no knowledge, and this case is not about, as stated in her claim, the repair of the vehicle.
I'm not suing for the repairs.
Right. That's
I was just
what she's
stating.
saying.
Hi, Maiko. Number 4? Holy cow, Maiko. That's the lowest. I've never seen you get a number that low, Maiko. That's amazing.
Yeah.
Saying that it's not necessarily relevant to the particular issue. Really, the only thing that we're here for is the diminished value.
Right.
So just need to see kind of where the market value was
Yep.
prior to the accident, where it is now, and what was paid out. That's really kind of what she's getting.
The reason I referenced that is because that's when they cut the check. That since then, when they cut the check, it was $6,000 in repairs, and then it went all the way up to $21,000 before the car was done.
Objection, Your Honor. Relevance.
Okay.
This is a diminished value case, and evidence about the repairs are not relevant to the case.
Yeah. I'm going to
Okay.
sustain it. I understand. Just.
That's fine.
Doing fine.
Okay, so the diminished value check was issued before multiple supplements and before the full scope of damage was known. When the check was issued, I delayed cashing it and confirmed with Allstate doing so would not constitute acceptance as payment in full. Allstate confirmed, and I also wrote not paid in full on the check.
And Your Honor, she has, does she have a witness to speak to the Allstate of?
This is the opening statement that the lawyer keeps interrupting. Just saying. Not evidence. Opening statement.
Objecting of, I'm sorry, Allstate advising her of the permission to, I believe she said permission to cash the check.
Yes, Allstate. I have a recorded call. If we wanted to reset this, I could get the recording calls and the transcripts from that call with Allstate themselves.
I would object to the I believe she's alluding to a continuance.
Yeah.
Right.
I would object to that based on the date of filing and the notice that, to bring that based on, it looks like she filed in December, so she had from December to now to bring those recordings in.
I got the check. I mean,
You're fine. Just hold on one second. So as to your objection, I know that Allstate is not a present party in this particular lawsuit, so I guess that would be your objection as to hearsay.
Yes,
Since they were not a
They're not.
named party in the lawsuit, it's not a party statement.
yes, as well as they were not notified that they needed to be here to testify to the phone calls that she is bringing up. I would advise to lay a foundation for those calls if she has them, but she has notated that she does not have a record of those calls in here today for me to review.
Diminished value reports say that
See if we
7,000 or
could
5 million, that's basically what they want to hear.
not have an objection is the best way I can say it, but
Okay. And then, I'm sorry, I may have missed one thing, and it obviously has no real, I guess it has some relevance to this. Were you privately retained, or are you insurance retained?
I am retained through Ms. Yao and her insurance.
Okay, okay, I understand.
okay.
All right, so Yeah, so go ahead and continue.
Okay.
Don't talk about what other people said.
I won't.
Okay.
I have a copy of the check where, and you can see the date I deposited it. I held it for a long time. And on the check, I wrote not paid in full before I cashed it. So that also represents and there was a letter that I sent to Allstate. I sent it to the claims adjuster. I sent it to the repair facility and even the regional manager and corporate, saying that this diminished value is not acceptable, that I dispute it from the get-go. They didn't even talk to me, and the repairs weren't even done, so.
So I assume that you're probably wanting to submit the letter
Yeah.
and the check. So
Yep.
go ahead and hand those over to us, please.
Okay, here is the check and the, where I wrote on the check, so I got a copy from my bank.
I told all my coworkers Micah was back, and they were like, "What?"
Oh, I'm sorry, I didn't give it to. And then, do you want the letter that I sent to corporate? Okay, hold on, just a second. This is the, oops, I thought you needed. Thank you.
Can I get a copy?
Yeah, we can do that. Can you get
I
copies of
will
the
take your copy.
Did you have any objections to it?
No, not at this time.
Okay.
YouTube is never gonna let him type the answer, Monica.
Yeah, yeah.
All right. So the letter shows, while she's getting copies,
Yep.
the letter shows or says what?
It says that I disagree with their diminished value determination. And I was fighting I was trying to avoid them making repairs along the way and it totaling more than what they would before they would total the car.
Objection, Your Honor. Again, this case is not about the repairs. Thank you so much.
That was about what the letter was covering. So should I continue?
Hold on one second. She gave away my papers.
Okay.
It's okay. I get it. I understand.
Here, okay.
Do you
For the
have?
first two exhibits that she presented, 'cause it looks, I'm gonna say this is three different exhibits, or are we saying two?
It's two exhibits. I took a staple out of the one that looks like an email.
Okay,
Might be an email chain is what it is.
Okay, I am okay with the, it is listed at the top, insurance paid diminished value in part, as well as the Chase of Business deposit details. I'm okay with those coming in, but I am going to object to the email coming in, just based on the fact that this email appears to be a document not drafted by Ms. Federation. The contents of the document appear to be something that was not drafted by Ms. Federation, so she is not able to testify to the information within the email.
I don't know who it was drafted by then.
I guess I'm assuming you're really looking at portions or pages
like
2 and
it's-
3.
The first one looks like it's something from Diminished Value of Georgia as well as Rec Check. If you see that little symbol in the first page in the bottom. right-hand corner.
Oh, yeah, so you're saying the bottom half, like bottom quarter of
Yep,
it
everything
would
that
be-
says diminished value rec check going.
I submitted the wrong thing.
Oh,
If that's, okay, thank you, sorry.
you're perfectly.
Sorry, I was looking for, I told you I'm nervous.
They're all-
Hold on, I'm looking for the letter to corporate is what I was trying to.
Methany. That's my new name, Meth. She's nervous. She submitted the wrong documents, but it's okay. It's okay. Don't worry. The judge is outstandingly chill with both the lawyer and the pro se this hearing. He knows this is going to be a huge struggle. We're going to find out why soon.
Sorry. It's funny, I have them all tabbed on the right, and now I don't know. I don't have it in order. I apologize,
You're fine.
can I, no. Can I provide the letter that I sent to corporate from my phone? From email? Okay.
We do that all the time.
I have my phone off. Sorry.
You're being good. I understand.
Should I, while I'm trying to get that up, should I continue with this statement?
You can. Anything else that you want to talk about?
Okay. Okay. And again, I want to emphasize that this was not a minor accident. It took 2 months to repair the vehicle. And here's the issue. The vehicle now carries Carfax branding of moderate severity damage and functional damage, including airbag deployment, which permanently affects the resale value and the trade-in value regardless of the repair quality. Georgia law requires insurers to assess and pay diminished value based upon actual market loss and not internal formulas. And I have State Farm versus Maybury and the Georgia Supreme Court held that diminished value must be evaluated using a method that reflects real-world loss after repairs. And Myers versus Thornton confirms that permanent impairment in value is recoverable separate of repair costs. Because diminished value was determined before the full scope of repairs was known, I obtained 2 independent third-party appraisals, one from Georgia Diminished Value and the other from RecCheck. And Georgia Diminished Value puts it at the high of $6,650, a mid-range of $5,014, and the RecCheck puts it at $4,950.
I'm going to object to Your Honor that she has not brought anyone from Diminished Value of Georgia or RecCheck to testify to the expert number she's speaking of.
They give you a report, and on that report, it outlines, this is a report from Georgia Diminished Value, and they have, they include everything, including patent applications to their progress or process. It has the low, medium, and high value and what they based it upon. That's this report.
Give the full report and let's look at the report and see what you think.
Thank you.
Where's the second one?
Oh, and then RecCheck. RecCheck, which is the one that my insurance company recommended. That's what they use, and I also have a letter, I don't know if you would accept that, from a appraiser for Progressive, an auto appraiser, said that he uses RecCheck. But RecCheck is not as thorough as that one. I didn't have to pay for this one, but this is RecCheck's. There's 2 from RecCheck's, one during the process and one at the end.
Okay. I will, I'm so sorry.
You're good.
If I could also get copies of those, but I'm going to object to the admission of those as she has no expert to speak to those. She does have to have an expert witness sign off on those things to speak to how they came to those numbers. Based on the information provided, she put into the website what she believed was the most accurate information, and it gave her a number.
No, that was RecCheck, not the Georgia Diminished Value.
Okay, understandable.
I'm sorry, I checked.
That's exactly how it works.
Yeah.
So how do you think this lawyer is doing so far?
No,
And
you're
so
doing good. Everybody-
I- Yeah, and so I am objecting to the lack of expert qualifications, no signature on the back of it, no one to cross-examine that is an expert in the field for those documents. And specifically the methodology.
I object.
Do you need to pull that up? Oh, yeah.
All right. I'm gonna do this. I'm going to sustain the objection as to the rec check currently. And I'm going to,
James, I just have one question for you. Hi, James. Do you know Snooky?
currently reserve on the diminished value, Georgia diminished value report.
No.
Just so that
Do you know the Long Island Medium?
I
Sorry.
can kind of see what's going on.
Sorry.
But I hear
I'm Pennsylvania. I'm right beside you.
your objection. Okay.
Okay.
Will you give her a copy of that?
higher one.
And then we'll get that.
Please give me the better report. Thank you.
Okay. All right. You can continue.
Here is my, my email. Do I give this to you first? This is my email to Allstate Corporate. I hope.
So sorry.
While they're looking at that, I also have the Carfax report that shows the accident, the severity.
I told the police Bren did it. told the police Bren did this.
Of the accident and the airbag deployment, if I could submit that as well. Are you okay with this going to him?
Yes, Your Honor. Apologies.
No, you're fine.
Don't look through my phone.
Listen, I don't go digging for nothing.
I'm kidding.
And I would object to the Carfax due to the expert. It doesn't appear to be assigned documentation.
I object.
Cross-examine someone for the information on this document.
Carfax is only ever a report. It goes with the car when you're trying to sell it.
And if it pleases the court, it does, based on what I read, I actually do have a physical copy of that email you're reading.
Oh, good.
That would have saved us time.
I was trying to make sure, let me see what you're gonna present first.
Thank you.
No, you're good.
And I will say that that letter appears to be going to a person and not our corporate office.
Okay.
That's what she just.
I actually sent it I uploaded it to the portal. I sent it to the vice president of Allstate Claims and another executive in the corporate escalations department.
Do you have an exhibit for that?
You do.
You're saying all those people are listed on that?
They're CC'd on that. So that went to more eyes than just the person who's named my address at the top. I try getting anybody's attention. And that's before the total damages, that was early in the process.
Let him read.
Sorry, you're right.
I ask every single person who says they're from Jersey if they know Snooki. Everybody, all my customers who walk in to my bar or wherever I'm at, I'm from Jersey. Oh my gosh, do you know Snooki? I think you're 3 or 4 miles off.
And I'm, based on the contents of the letter, it appears to speak more to the repair of the vehicle than
No, I wanted
to the diminished value, as well as expert that is attached to this. Her claim is regarding diminished value only. Ask the court to.
I object. At the bottom of this first page, it says that in addition, I was issued a diminished value check for $789, which is not evenly remotely reflective of the true diminished value. That's in the bottom of this.
I'm okay with that line coming in.
Right.
Do I?
You can walk forward.
This
you
is
know.
my, okay, I was like, this is. do I
Well,
keep
that's
this
true.
or
It's
do I need to
technically,
give-
it's technically yours.
Yeah.
Just hold on to it for just a second.
Can do.
Just hold on to it for just a second. If I ask for it, I'll ask for it. All right. You said Carfax, you had the same objection, no experts currently. That's okay.
He wanted to testify to the effectiveness of, or
And I
who
object.
drafted the report, who pulled the, like, any expert information about it.
Your Honor, I object. Anytime you get a car, you pull a Carfax report. And if there's no weight in that report, then Carfax's existence is pointless.
Yeah, I think
That's true. She did good there.
with regard to the Carfax report itself, I think that generally that is kind of an industry standard as to a reliable source for valuations and at least history of a vehicle, like crash history, et cetera. And so I think that I would be within my authority to take judicial notice of the report itself. It's kind of been a vetted thing since, 2005-ish, I believe is when they started. So I think I'm going to allow this one. So I'm going to overrule the objection as that issue.
Okay, now since you just got overruled, I'm gonna give you a spoiler alert. This is this lawyer's very, 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 very first trial. And the judge doesn't know this yet, but the judge suspects it highly.
All right, so I have the report.
Okay. And then, in addition to the, what I've presented so far, there's accident-related damages that were not paid and are not a part of diminished value.
Objection, Your Honor. Her statement of claim, I do have a copy of it, just in case we don't have one.
Oh, no, I have it
Do
somewhere.
you have the complaint up there, Your Honor?
I didn't know that, Maiko. Thank you. I'm gonna try it.
Okay, so I do have her statement of facts supporting claim. It is a separate word typed document. And I believe it was, when it was sent over to me, I think it was a page 5, but I reorganized it to be proper. If you would like a copy of those.
Sorry.
There's always a principal stuff paper.
feels thicker than what it is.
The lawyer is exceedingly kind to the pro se lady. Just fast forward 10 years
Yes.
from now.
I would like
Lawyer's going to be a different person.
to call attention to the fact that this is not, that Your Honor, this case is not about the repairs to the vehicle. It is only, or I'm sorry, it's not about repairs to the vehicle or any outside claims for diminished value. So and I would ask the Honor to sustain anything mentioned that is not diminished value for this lawsuit. The plaintiff did submit an amended complaint. However, it only notated.
You can always, yeah, you can always come back.
You know, like I'm an officer of the court, but I don't want to get on his bad side. This is her amended complaint. It's amended at the top. It has a updated value with no new statement of claim addressing anything outside of diminished value. So I would like if we could state only on diminished value assessment today.
Yes, okay, yeah, I mean, I agree with that.
Your Honor,
Yes.
when I did the amendment was for the additional damages, and I was told that I could present it at the time, that I didn't have to include it on the amendment of statement of claim by the court. I said, do you want me to submit it ahead of time, the details, or do you want me to bring it to court?
Okay, hold on 1 second.
Okay.
Let me just- Can you actually bring this back up for me?
Yep.
Before I try to include this.
Right. That's what I'm saying. That's why I amended the claim. I amended it to include that. That's the whole point of amending it.
Also, Your Honor, the Carfax that you agreed to admit, can I get a copy of that?
Yes. All right,
I know you're not going to believe me, guys, but this whole trial is actually sped up. I have it on a higher speed than normal. Rebecca! Hi, Beck.
all right, so just so that I'm abundantly clear, when you amended your complaint and went up from the
Hi, T.
$4,496.41 plus court costs and went to the $7,889.79. Was all of the additional repairs, or was there additional diminished value? What was going on?
It was additional damages outside of diminished value because I realized I was focusing just on the diminished value number.
Okay.
And so then I called,
So it's not necessarily for repairs?
no, it's damage. Can I explain what that additional money's for?
Give me a little bit more.
I got a bill after the fact from Enterprise Rental. The car was in Allstate, the rental was in Allstate's name.
Mhm.
And they stopped the car repair place said it would be, I'm just going to use an example. They said it would be ready on Friday. And then they told Allstate that. And then they said, no, it won't be ready until Tuesday or Wednesday. So the Allstate stopped paying the car rental and said, I have to return the car. I'm like, my car's not ready. How can I return my car, the rental car? So I got sent to collections, I just found out, for a $900 bill that Allstate isn't paying. I told them they need to pay that bill because now it's falling on us and we can't rent a car, I can't do anything. And they said, no, I'm suing them. I have to add it to the court case. So that's what I added that. There's a brake light that had to be replaced. That is not a part of diminished value. Allstate denied covering that because it had a crack. And I have a Georgia case that says that even if there's a pre-existing damage, that they still have to pay if it then becomes where it has to be replaced.
Okay. So,
Damn it, Michael. I tried jumping up and down to make the medicine work faster, and look what happened to my face.
all right, so you have the rental, you have the light that had a prior crack.
A slight crack, yep. And then now it's broken, had to be replaced.
And then how how much other things are included in this?
There's only a concrete bumper, a parking, my driveway, it has a driveway that goes like that, and then right here is where my car was parked on a parking pad with, just like a normal parking lot, has a stopper, that concrete thing. That, when my car got hit and forced, it broke a chunk off of it, like this big.
That's not damage to the car, that's damage to
No,
the
yeah, that's just replace, that's a $200
Right, okay. And
thing.
then anything else?
That was it.
Hold on, I had to give myself a cheat sheet. $893 for the unpaid rental. The $611 for the brake light, $200 for the parking stop, $275 for the diminished value appraisal that you have that's certified for diminished value appraisal of Georgia, and that's it. So it's $1980.37 in other charges other than diminished value.
And Your Honor, I would object to all of those except the 275 appraisal for diminished value. And I would also ask for clarification if that 275 is additional or was it included as a part of the original?
Additional.
We want to pause until I get the statement of claim back. Just a moment. Thank you so much.
These are your
Okay.
copies. Let me think about this additional issue of the additional damages for just a second. Go ahead and continue with some additional stuff for me.
I have hydroxyzine. How did Benadryl? Okay.
Is that it?
I have,
Monica, thanks for the cheers.
Sorry,
Thank
Monica.
you.
She did notate that the 275 is additional, however, it is notated in the original complaint. That's what I wanted to confirm.
Oh, gotcha. Okay.
but not included in the diminished value request.
I gotta work though. I can't really.
Okay,
take
so I wanted to make sure that the court knew they already paid the $787. And I included two different numbers for the diminished value, the mid and the high. And I didn't have a set dollar amount because there's two different numbers that the courts could, well, any number the courts could deem appropriate. But I wanted to give the range, and that's in that Georgia diminished value. And I think I rest. And if you need anything,
I gotta work today. I can't.
if you want my
or this.
statement with all or the exhibit overview, I have that, where if you want to see anything specific, you can. And I'm sorry, Your Honor. I also have a comparable market listing of my car to show what the value is now versus what a trade-in value was for the car. So the car did realize, and that's when they told me it's because of the Carfax report. That's what prompted all of this.
Okay.
Okay. Ms. Federation brought
Only
up two
to the
letters,
police.
and I want to confirm which ones were admitted into evidence. The one I have a copy of here, and I want to confirm this is the only one that sounded like you sent 2 to 3 letters that you sent over. So the one that we are agreeing with is the one that I presented to the court, titled one of the many letters sent to Allstate, and is addressed to the corporate office.
That's the
Where
only
is
one.
the
That's the only one I have fully read in its entirety.
Do you have others?
is there-
Just one, if I could look at the email that I submitted originally to see how because, can I see the email that you have?
This is the one I have.
Thank you.
Or the letter. It's not not an email.
Why can't nicotine and caffeine ever be the answer? Why? I did say Bren punched me in the face. I did start it. That is true.
This isn't I've sent multiple emails. I have one on my phone if you'd like to see that as well, but this is the gist of,
So,
I just want to confirm, you mentioned a couple of letters. I just want to confirm that you are only presenting this one to the court and all other letters are not being presented to the court.
this one is more recent. Should I have you continue?
can't tell you that. Can't tell you that.
Okay,
Sorry.
well, I am afraid that if I don't submit this, you may glean something from this that would be in my favor. So can I have
So
you?
just let her look at it one more time.
Yeah. Just in case.
You're good.
Okay, yes, this is the second letter. I believe she had you on her phone.
Yes.
And
This is, I think it had a name and it had Mike or something.
yes, this was presented to a Mike. Just says Mike. So I would check that we don't
know
have
who Mike
foundation
is.
who this was from, and then as well as I wasn't confident in the confirmation of whether this letter to the corporate office was sustained or admitted. And my objection would be that there's no one from Elk State's corporate office to speak to the receipt of this letter.
It was uploaded to the Georgia Insurance Commissioner in a complaint. I can log on to their website.
Given that her communication for a claim is primarily with a person, assuming
I love
possibly
cabbage.
Mike, this is sent to someone completely different.
Okay. I just let me review that one, and then as to that one,
And I would also say this is a letter about repairs. This is a letter primarily about repairs, except for
the last end of it.
yes.
And on that, if you notice at the top, it says Allstate, the guy's name, Mike Fiato, or I don't know how to pronounce it, at allstate.com.
I'm going to allow both letters currently, okay? So overruled currently on the objection. All right. Anything else?
I do. I have something that was given back to me when I accidentally submitted it. When you have a claim with Allstate, you have to submit through a portal. And I submitted, you have to send it to claims@allstate.com, and you have to have your claim number in the subject line. That's how it gets uploaded to the portal.
Mm-hmm.
So I submitted this diminished value appeal, and it says that the original Georgia diminished value claim, diminished value was at $4,300, but that's early in the repair. Again, it's early in the repair process.
Objection to the mention of the repair.
And on here, I say Allstate already issued a payment of $778, which is wholly inadequate given the evidence. Therefore, I'm demanding payment of the balance.
No, I love
And
cabbage.
this whole letter right here was about me disagreeing with the diminished value back in September.
Okay.
So can I submit that?
I think I have.
Okay.
I think I have that
Okay,
clear.
thank you.
I don't think I need another document about that one. Okay. All right. Anything else from your side?
I don't think so.
Do you rest?
I feel like that's a trick question.
It's not.
This
It's
is
not.
usually asking for permission for my
Continue.
side to go.
Oh, yes, yes.
Thank you. Your Honor, I would like to call back Ms. Baron Federation to cross-examine witness.
Yes.
And is she still under?
We'll still say she's under.
Okay.
Yeah.
Under oath.
Can I object to that?
No. No. Unfortunately, you can't. Sorry.
Who else knew durian fruit was going to jump into this conversation? Who else knew? I knew. I was ready. Man, I don't care about the swirling, but what about the itching? I need something for that badly because I'm about to break stuff. I'm about to break something.
Okay.
I'm old.
Ms. Federation, you filed a diminished value claim related to your 2023 Kia Sportage. Is that correct?
Correct.
After submitting the claim, you received a written correspondence from the insurance company about the diminished value claim. Is that correct?
Not that I'm aware of.
They are. They're so nice to each other because one's pro se and the other one is brand new, very, very, very first trial. So they're like, I can't. It itches too badly. I can't. It's impossible.
Okay. I believe you
I'm actually
submitted
closer to Philly than
evidence
Pittsburgh.
already, a letter that you received from Allstate, your very first.
Oh, the one with the check.
Yes. Did you receive any written correspondence at all from the company Allstate Property Casualty Insurance? Written in terms of an email, a letter, a portal, any communication from Allstate to you in a
Yes.
written format?
Yes.
Change that answer to yes. May the record reflect that the witness has received written correspondence from Allstate. The next question, that correspondence explained the results of the diminished value evaluation. Is that correct?
No, it did not explain it. It outlined what the value was, but that was it. It didn't explain any of their reasoning. So no. Nobody spoke to me before cutting the check. All of a sudden a check showed up.
I would ask that you, Your Honor, that you negate her last sentence and just negate the last sentence to confirm.
So when she cashed this check, she wrote on the check, I can't remember now, something like, this is not all that you owe me. She wrote something else. I can't remember what she wrote. But she wrote that on the check. This is not a final settlement. This does not cover everything, blah, 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 blah. So what does that mean? Legally, what does that mean?
You are advising that the correspondence did not explain the results of the diminished value?
Yeah, I wouldn't call it correspondence. Oh, sorry, is that yes or no? Can you ask me your question?
No, yes. The correspondence that you received via either email, letter, or portal explained the results of the diminished value evaluation. Explained the results.
Yes, just the results. Yes.
The letter stated that the insurer, which would be Allstate Property and Casualty Insurance, completed its review of your diminished value claim. Is that correct?
Correct.
The letter stated that the insured determined the diminished value to be $778.59, correct?
Correct. At that time.
I would.
All right, that's all I really needed to know. JK, you just answered all of my questions.
Your Honor, have the witness answer in the affirmative or unaffirm to these questions. You could just direct her to answer yes or no.
So the way that I always handle it is a yes or no, and then you can elaborate, or you can move on to your next question.
I understand. Okay. And so just to reconfirm, the letter stated the insured determined the diminished value to be $778.59.
Yes.
The letter stated that the $778.59 was issued as a settlement for your diminished value claim. Is that correct?
Not
Say it one more time.
No, not a settlement.
Along with that letter, you received a check from the insurance company. Is that correct?
I'm confused. Now are you referring to two different documents, a check and a letter? Because there was just the thing attached to the check. That was it. So there was no per se correspondence. It was just, here's the diminished value. You saw that.
Along with the, I'll say it again.
Or
Along with the
seashells,
letter you
Micah.
received, there was a check issued by the insurance company, Allstate Casualty and Property Insurance. Is that correct?
Sure. Yes,
The check was in the amount of $778.59, correct?
correct,
The check was made out to you, Veron Federation.
correct.
You had possession of that check, correct?
Yes,
You deposited or cashed that check, correct?
eventually. Yes, correct,
The check cleared your bank.
correct.
Is it correct that you received the funds from that check? It's essentially the same question.
Yes, yes.
You kept and used those funds, is that correct?
I kept, yes.
Not a lot of questions, I promise.
It's okay. After mine, I don't mind.
After receiving the check, you did not return it to the insurance company, correct?
No. They said there was no need.
No. Yes, I'm sorry, let me rephrase that. After receiving the check, you did not return it to the insurance company. Is that correct?
No, I offered, but they declined. No,
You did not return. Okay. You did not send the check back uncashed. Is that correct?
I offered, they declined.
Is that a yes or a no? You did not send the check back.
No, I did not.
You did not send the funds back after cashing the check.
No,
You did not tender payment of the $778.59 back to the insured within 90 days of receiving the check. Is that correct?
no,
And you cashed the check before filing the lawsuit. Is that correct?
correct.
At the time that you cashed the check, you understood that it was related to your diminished value claim. Is that correct?
Yes,
And you did not ask the insurance company to void the check. Is that correct?
not correct.
Okay. And so you asked the insurance company to void the check.
I asked them if they wanted it back, if they wanted me to tear it up, whatever they wanted me to do. And that's the phone call that I referred to where she told me it's not necessary to go ahead and cash it. That if later,
Check. Well, I'm gonna ask John to do.
What about that, JK? It sounded like if that evidence was allowed, that the lady on the phone told her to cash the check, it didn't matter. Then what does it mean?
Direct the witness to answer the question as asked. And I'm gonna ask it again, if that's okay.
Yeah, rephrase the question or re-ask the question.
Okay, you did, it is to your understanding that you did not ask the insurance company to void the check.
wait, hold on. It's to my understanding that I did not ask. I did ask. I don't know how to answer that question. It feels like I asked them if they wanted me to void it or if they wanted it back. You have that I did not want that, so I don't know how to answer that question. I did offer to tear it up and send it back.
Okay. Is it correct that you received a phone call from an independent appraiser by the name of Charles D. Stewart, sometimes known as Chuck Stewart, of Professional Estimating Services Incorporated?
Yes, I did. A couple of weeks ago.
And
listening, T. I'm listening.
Did that appraiser advise that he needed access to your vehicle?
Of cigarettes. Please say of cigarettes.
Yes,
Is it correct that you did not allow access to the vehicle?
correct.
Is it correct that he reached out a second time to ask for access to the vehicle?
Will I get a chance?
Of Girl Scout Thin Mints. Say that. Tri-pack ice. Are you telling me to put ice in my face? I happen.
To come back on this rather than just answering her questions as well?
Technically, yes.
Okay, good. Okay, what was your question again?
Did Chuck Stewart reach out a second time to appraise your vehicle, to inspect your vehicle. I apologize. I'm going to say it in a full sentence. Did Chuck Stewart reach out to you a second time to ask to inspect your vehicle?
I'm not sure a second time to inspect it. No, I don't think so. One time. I think. I'm sorry.
No, you're okay. So to the best of your, well, you said I think.
I know,
I would ask for a firm yes or no, to the best of your knowledge.
I don't know that there was a second.
knowledge.
Yeah, no knowledge of a second time.
Is it correct that you do not have anyone here today to speak to the diminished value appraisal?
I have an appraisal. No, I don't have anybody here physically to speak to it. It's in writing.
And is it correct that you did not hire an expert appraiser to inspect your vehicle?
I did. Georgia diminished value.
Is it correct that your vehicle has not been inspected in person by anyone with a license to inspect or appraise your, for diminished value?
Not true.
That is not true.
Correct. They did themselves. The appraiser went out there.
And the repair shop.
And did the repair shop. And this is on, by the way.
Can you advise who inspected your vehicle in person?
There was when I brought up the diminished value dispute, the Allstate appraiser and his supervisor went out to the repair facility to inspect it.
To inspect for repairs or to inspect for diminished value?
No, to inspect the repairs and,
Oh, I would ask.
okay,
Just to stop at that.
okay.
Repairs. So to the best of your knowledge, no one has inspected your vehicle. No one has, I'm so sorry. I would strike that question. Because I know I'm missing one. Let's see. I want to confirm, it is correct that you are the controller who allows access and denial of access to your 2023 Kia Sportage.
Yes.
You are the sole,
Oh, no, my husband too.
you're, okay.
Pineapple juice is the best. It goes with rum, vodka, whiskey. It goes well with all of them. Universal.
And it's correct that you were the one who spoke with Chuck Stewart and denied access to reassess the vehicle.
Yes.
I do, but only an act of God would make me put anything on my face right now. It is burning and itching and cracking and burning and cracking and itching.
When did you cash or deposit the check? Was it, sorry, that was the complete question. When did you cash or deposit the check? I would direct the court to the first exhibit presented as well.
I think I gave my, yeah, you got it.
Okay.
That's my
need you
deposit.
to,
That's it. No problem.
That's delicious, Bren. It's delicious.
The check was written on 8/14 and I deposited it on, no, wait, hold on.
I mean, that is a highly superior drink you just typed in. It's so good.
8/14 and I deposited it on, sorry.
I can underline it if you need it.
There's a conflict in the dates here.
On your exhibit?
Yeah, I don't know, because I couldn't have deposited it 2 weeks before it was written. It says it was written on 8/14, but then what's weird is it says its post date is September 8th, so that's impossible. I don't know what.
8 is August and then 9 would be September.
Yeah,
Oh,
you're good.
Just
You're just
nervous,
thinking a
it's
little too.
Yeah, Jean's a smart ass.
yeah, I saw the
I'm sorry.
September 8th and I,
Nope, you're good.
8/8, okay, yeah.
Jean,
So
I
I
love you.
cashed it on September 8th and it was written on August 14th. Do you need these back? Sorry.
No, you're fine.
Almost.
Understand completely.
And so that is approximately 3 weeks. Is that correct?
Correct. Yep.
And my
I consume more Malibu than any other alcohol.
My last question is just at the time you cashed the check, what was your understanding of what the payment was for?
The diminished
My
value up
baby
until that
Jesus.
point of the repairs.
Thank you, Your Honor. I have no further questions for this witness. I would like to call my second witness if able. Okay, Your Honor. My second witness is appraiser Chuck Stewart. He is unavailable today due to a prior trial being had. I do have a signed affidavit on his behalf to attest to his inspection or denial of inspection of the vehicle in his appraisal report. I would like to move to Defense Exhibit 1.
I object.
You can provide her a copy of it.
Thank you.
We've had the car back in our possession for how long? And they never say
No,
anything.
he's not going to tackle you, I promise.
Malibu Bay Breeze.
Yeah, I'll allow the affidavit.
Okay, thank you, Your Honor. I would like to notate
Butterbeer.
line item 5, that on or about February 6, 2025, as well as February 6, 2026, and February 9th, 2026, that Chuck Stewart, a licensed appraiser in the state of Georgia for diminished value, contacted the plaintiff to coordinate inspection of the vehicle, as well as line item 6, that the plaintiff refused access for inspection of her vehicle.
Okay.
And that Mr. Stewart, after this, apologies, Your Honor, one moment. As well as line 8.
Did my stream just go down? Sorry guys, I think there's a technical glitch on YouTube's end. Let me just wait. I don't understand. It looks like you guys can see it now.
8, where because the plaintiff denied access to inspect the vehicle for reassessment of her diminished value claim, Chuck Stewart used the photos that was submitted to her claim, as well as the post-repair vehicle listed on Jim Shorkey's collision website.
I object.
What's the objection?
I object because he's not here for me to, she said that he evaluated this based upon the diminished value. And if I could elaborate on why I object to his interjection at all.
But yeah.
Okay, when I received a phone call, he said he's coming by on behalf of Allstate to make sure, I felt like it was deceptive. He said wants to come by to make sure that the repairs were done up to Allstate standards. And I said, really? They're having you come by 4 months after the repairs to make sure it's done right? This sounds a little fishy. I didn't even believe who he was. And then he said, yeah, I said, oh, I get it. I said, so you're trying to, because court's coming up, I said, you're trying to come out here to see if the repairs were done so you could negate my claim for diminished value. I said, diminished value has nothing to do with whether or not the car has been repaired. Diminished value, and I explained it to him, the difference. And so then we got off the phone. I said, no, you're not coming out here to look at the car, especially when you come at it like it's deceptive. And him and I got into it because I said, if you would have approached me in a different way, then rather than trying to be shady about it, I would have had no problem. And then he said he could come by if he wanted to. So we parked our car behind the house.
They hid the car, guys. Hi, Lucy. They hid the car behind the house so that the inspector couldn't find it. Bren, they probably sell it in the United States. Probably. But that doesn't mean we see it. When we shop, we have so many options that we don't see them all. We don't. We sort of go to the grocery store, whatever store, and we get what we get. Because the grocery stores are humongous, and there's too many options. There's even just too many options of Pop-Tarts alone. So if they sell something from Australia, here it's probably in in a section of international stuff that we sort of kind of gloss over. So yeah, they might sell it here, but we might not see it. I just wanted to say something and I lost it. Bill's here! Bill! Oh my gosh, I almost just ignored Bill completely. Because, he came in while I was talking. Look, guys, it's Bill. Hi, Bill. Bill, I love you. Alright, I'll be right back.
I'm going to allow it currently, okay?
Okay.
Continue.
I would like it noted that line item 9 on the affidavit, the measure of damages is the repair cost plus that he evaluated diminished value at $2,745, and that the professional estimate of the pre-accident value was $29,850. That the post-accident retail value in line 11 is $27,105, and that his expert conclusion was that the diminished value is $22,745.
I object. And the reason I object is the numbers that he's using on the market. The car has 15,000 miles less than mine, and that's one example.
Wait, what are you?
On the last page of his report. Sorry, not the last page, hold on, before the photos. On the estimating service, the second page of his, let me see, it would be page 1, 2, 3, 4. Page 4, where he gives the history and market, that is so subjective. And I have this.
It's already admitted this document.
I mean, the document's admitted. That's
Okay.
that. I'm going to weigh everything that's been admitted. So, just so that I think you're getting there. I'm assuming, based upon this document, the diminished value method of Mr. Stewart is 15% of repairs. Is that?
Your
That's what we're getting
that
at.
is correct, yes.
Hi, Salty.
All right, you can continue with anything else.
That is all we have today, Your Honor. The defense rests. I'm sorry, the defense, my witness isn't on the stand, so I would like to,
You have another witness?
no more witnesses.
No more witnesses. And you do rest?
I do rest.
All right. And you were provided a copy of this, correct? The affidavit from him?
Yes.
With all the stuff?
Yes, I do have that. Your Honor, I have a list of, if you're weighing that affidavit, I have a list of market values that support a much lower market for cars with one accident.
I would object that the plaintiff has rested her case. And
Well, I woke up.
that was a good one. I haven't heard that one. I haven't heard that one before.
To add that into my repertoire. So no more additional evidence. The only thing that I'm going to allow is where we went into that additional cross-examination portion, if there was anything relative to what was crossed that you wanted to add.
So does that include the document, the affidavit of Charles Stewart?
It just means if you were contacted, all those questions that she asked you,
Those
Okay.
yes or
Was-
no questions.
those yes or no questions. Was there anything else that you wanted to clarify?
No,
Okay, all right.
no, sir.
Okay, let's see. So now it's time for closing argument. If you'll go ahead with close, please, and just tell me again kind of what you're asking for, why you're asking for it,
Okay.
and then we'll go to the other side, okay?
This was not just about diminished value, it was about diminished value and other damages, but coming into this, everybody seems to be, that's approaching me, seems to be clouding what diminished value is. And it has nothing to do with if the repairs were done correctly. An attorney, I don't know if it was, I'm sorry, I forgot your name.
Attorney Johnson.
Attorney Johnson. I don't know if it was Attorney Johnson or not, but when they originally approached me, they said, well, the car has depreciated anyways. I said, diminished value has nothing to do with depreciation. I said, this is because of the Carfax, if I try to get out of the car, which I already did try to get out of the car, because the car was just about totaled. So surprisingly, but because I will suffer a loss when I go to sell it because it's had an accident. And then the counsel said, well, it's not like they used parts. I said, as a matter of fact, they did. A lot of the parts on the repair were used parts from a junkyard. And so, but that's not diminished value either. It's what the market interprets, that your car is diminished in its value as if it were a no accident, the difference between an accident and no accident. And that's what I've been arguing the whole time. As the repairs grew, so did the diminished value. And meaning the total number of the cost of the repairs, whether or not it was a minor, major, that's what goes into diminished value. And I'm just trying to be made whole out of this entire process. That's what this argument has been since the beginning. And I really wish that Allstate would have totaled the car. But once they got into it, the way the repair shop did it, it was in steps. So they've already committed too much money to declare it a total loss and had to repair
Hi,
it.
Sherry.
So now I've got a, let's say $20-something thousand car value, which is hard to actually get a hard number on, versus a car that's had $20,000 worth of repairs.
I want so badly for her to win. Did we hear anything at all, guys? Did we hear anything at all in this case that lets her win this? Anything? We don't get a decision. We will in the next two cases coming up, though.
Defense.
Thank you, Your Honor. Ms. Federation, as the plaintiff, bears the burden of proving that she is legally entitled to additional diminished value beyond what has already been paid. I would say that she has not met that burden. First, Ms. Federation failed to present expert testimony evidence of additional diminished value. Diminished value is not a matter of personal belief or online estimates.
That's what I was waiting for. Thank you, JK. I think that she's going to win a little bit more money. Not as much as she wants. I think that he is going to award her a little bit more money. But not as much as she says she will.
It is a technical evaluation issue that requires specialized knowledge of vehicle markets, post-repair stigma, and resale impact. Ms. Federation presented no qualified expert testimony and no reliable independent appraisal establishing her vehicle pre-loss value, post-repair value, or any additional loss beyond what has already been paid. Second, and critically, the lack of evidence is a direct result of Ms. Federation's own actions. She demanded a reassessment of her diminished value claim, yet denied the insurance company's independent appraiser access to the vehicle, going as far as hiding the vehicle. Without physical access to the vehicle, a proper reassessment could not occur. A party cannot prevent inspection of the very property at issue. Georgia law does not award self-created evidentiary gaps. Third, and independently dispositive, Ms. Federation's claim is barred by accord and satisfaction under Georgia law. A claim under Georgia law is discharged when a disputed claim is settled by payment, the payment is tendered in full satisfaction of the claim, and the claimant accepts payment. That is exactly what occurred here. Ms. Federation was issued a diminished value settlement check on or about August 15, 2025, along with a letter stating that the payment was for the settlement of her diminished value claim. Ms. Federation then cashed that check on September 9, 2025, approximately 3 weeks after receiving the check. Ms. Federation did not properly reject the offer, did not return the funds, and did not tender repayment within 90 days as permitted under Georgia law. There is, Georgia contract law applies here. When a disputed claim is resolved by payment and the payment is accepted, an accord and satisfaction occurs and is binding on both parties. Georgia law does not permit a claimant to accept settlement funds and later seek additional recovery for the same loss. Once Ms. Federation cashed the settlement check, her diminished value claim was discharged as a matter of law. In the alternative, Your Honor, if you agree that she has received additional damages, I would ask that you use the independent appraiser's estimate as he is a licensed attorney. As he is a licensed appraiser in the state of Georgia for 10 plus years at the estimated diminished value of $2,745 minus the $778.59 already paid, resulting in a net of $1,966.41 plus cost. For those reasons, Your Honor, we respectfully request judgment in favor of the defendant. Thank you so much.
All right. Did you see?
I think she did show proof in that Carfax report. That Carfax report shows that this car now has, airbags deployed, crash, blah blah blah. So that is proof that it diminished in value more, because they didn't have that at the time they wrote the check. I think that Carfax report saves her a little bit. I don't know though.
All right. I'm going to reserve on this one just so that I can review everything a bit more intently and make sure that I'm doing everything right with regard to the objections that we had noted previously regarding evidence. So I'll get an order out, hopefully, not hopefully, let me put it on.
You gotta add it to the calendar, you'll forget, right?
Oh, yes, let me put it on the to-do list. Let's see, I want to do. Katie, keep me honest. I'm going to do gonna have a final order out by March 18th. If I don't, it'll be May. So I need to go ahead and get it done before things happen. All right.
Can I ask you a question?
Yes, ma'am.
Am I allowed to submit to the court the call recording where Allstate told me I can cash the check and it won't have any bearing?
I'm not going to accept any new evidence in the case, just because I think
That would have been helpful though, ma'am.
I have enough. I just need to make sure that I'm
Okay.
reviewing a couple of things and nothing
Okay.
good on everything. Okay.
Thank you, Your Honor.
Yeah. All right. So I'll get an order out March 18th. Thank you.
Thank you.
Are we excused, Your Honor?
You are. Thank you so very much.
Thank you, Your Honor. You have a good rest of your Wednesday.
Yes, ma'am. Was that your first trial? No. Judy Johnson and Diamond, y'all come on up, please.
Good morning, Judge.
Good morning. How are you?
So far, so good.
So this is only on a counterclaim, or does this have a counterclaim?
This is a dispossessory and there was a counterclaim submitted.
Okay, perfect. I got a little confused there when I saw the counterclaim notification. All right, let's see here. And then you represent plaintiff, correct?
Yes, Sam Bagwell here for Judy Johnson.
Perfect, thank you. All right. Get some general stuff going. So we've got, this is a dispossessory in regard to 55 Pirates Point, Dawsonville, correct?
That's correct.
And then, let's see, Heather. And then, sir, you are?
I'm Justin. I'm family friend.
Okay. Do you reside at the property or anything?
I do not, sir.
Okay, gotcha.
And we would invoke the rule if there's going to be any additional testimony.
Okay. Are you planning on testifying?
Not that I'm aware of yet.
Are you planning on calling him?
I might.
Miss Heather, are you planning on calling him as a witness?
No.
Okay, okay, good. All right. All right, you can go ahead and go with open, or if you just want to dive on into evidence, whichever one. This is both.
This is a brief opening, Judge. This is a property owned by Miss Johnson. She leased it to her son, and then her son has subsequently gotten married. Miss Diamond is her son's widow. Her son has passed on.
Sorry to hear that.
And so this is a situation where the landlord-tenant relationship, I think, is clearly established, but there is no formal written lease. So it's been treated as a tenancy at will, and we'll get into that throughout the testimony.
Okay, perfect. All right, and then, just so that I can have my goalposts, Miss Diamond, you're looking at a counterclaim, and I have $5,000 is what you're asking for, correct? And that looks like damages to personal property, correct?
Yeah.
Okay. All right, let's go ahead and go with this case in chief, please.
Thank you. Judge, if it's okay with you, may Ms. Johnson remain at the table?
Yes, you may.
Ms. Johnson, if you'll raise your right hand. Do you solemnly swear any testimony you give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. All right.
Jean did it. Jean did it. So, this woman was married, the woman on the left was married to the woman on the right's son. And they lived in her house. And then her son passed away. So, now the mom wants the woman out. Get out of here.
I'll try to run through the general matters relatively quickly. Do you own the property located at 55 Pirates Point here in Dawson County?
Yes.
Okay. Did you lease that property to your son?
Yes.
Tell me your son's name.
James,
And what was the rent amount that James was paying you?
$600 a month.
And at the time you leased it to him, did Miss Diamond reside with him?
They were not married, but she did move in with him.
Okay. And when did James pass?
August 5th, 25,
When is the last time any rent was received?
July 1925, 2025.
Okay.
That's a lie.
I'm going to show you the document. I'm going to ask if you can identify.
I let go of the ropes.
Sorry. That notice letter.
I do recognize it.
What's the date on that letter?
October 15th, 2025.
Did you authorize that letter to be sent to Heather?
Yes,
And was it sent to Heather?
yes.
Okay. Judge, may I approach? I'd like to attend to this as Exhibit 1. Combined.
Objection, Lord. Your Honor. I didn't receive this letter
Okay.
because it does not have my signature.
Judge, if I may proceed.
Huh?
If I may proceed.
Yes, you may.
Can you tell whether any of these were sent certified mail or regular mail?
I believe yes.
On the first page of that, was that sent certified or regular?
I believe regular,
And the second page, was that sent certified or regular?
certified.
Do you see any notation as to why the certified one may not have been delivered?
It said return to sender because she unclaimed it. She wouldn't accept it.
Did the regular mail version of this letter get returned?
Not that I'm aware of.
Do you have any personal knowledge of whether that mail was ever received in her mailbox?
I do.
What is that knowledge?
I took a picture of it.
Did this letter provide 60 days notice that you intended to terminate her occupancy of this property?
It did.
Did she move out during the ensuing 60 days?
She did not.
Okay. I'm going to move on to this packet. I'm going to show you. Do you recognize that notice?
Yes.
Is that notice, what's the date on that notice?
December 17, 2025.
And included with this packet, there are a number of photographs. What are these photographs showing?
That termination of her being in that house to her, showing that I'm showing that it's asking her to leave my home.
And can you tell what date that notice was posted?
12/17/2025.
And who took these pictures?
I took these pictures.
Were you personally present when this notice was being posted?
Yes.
Can you tell whether this notice was also sent by regular mail or certified mail?
This one, I believe, regular, this one's certified.
Was that document signed for?
Yes,
Okay. And does this notice make an unequivocal demand that she surrender the property?
it does.
Has she moved out since receiving that demand?
She has not.
May I approach it? And then these collectively did too. Was that unequivocal demand made at least 60 days after the initial demand?
Yes,
And did you wait at least 3 days prior to filing this subsequent dispossessory?
yes,
Has she surrendered the property since filing this dispossessory?
no,
Has any rent been accepted at any point during that time?
no,
Are you asking this court to award you possession of the property?
yes.
Thank you. We'll rest, Judge.
That was excellent. That was excellent. Good job, sir.
Your Honor,
Yes, ma'am.
when me and Jim got this house,
Well, hold on 1 second. I'm gonna go and swear you in if that's okay. You swear in front of testimony about to give you the truth, the whole truth, and the truth of God.
yes,
Okay, perfect. Go ahead.
when me and Jim moved into that house, we both paid rent.
Okay.
He paid $300, I paid $300. She accepted my rent all the way up to November of '25. Oh, I have bank statements, baby.
Judge, I'll object. If we're testifying and she wants to admit bank statements, we'll take a look at those documents.
It still doesn't change anything. Oh, unless she sent it out in December.
Yeah. With the,
You can't go past 26.
There you go. You should just open it. Yeah.
Is she looking on her phone? Because I don't hear papers. I think she's looking on her phone, but I don't know.
You should be able to open it from your downloads. Here, let me help you.
What are you doing?
Downloads.
I don't know where those are.
It's not going to pull from here. Do you have my file?
Objection, Your Honor. I love that they don't mute JK. You guys didn't hear the husband in the last case supporting her because you guys were talking in chat. He was excellent. It was amazing. She would say something, he would say, no, talk about depreciation. And she was like, okay, oh yeah, okay. It was perfect. Judy! Hi, Judy. But it'll randomly cut in too.
All the ones that say 300 are the ones that go to her. And it's always on the first of the month.
How far does it go?
This is all of 25.
So it scrolls and everyone,
She
That
said
says
May
300.
3rd.
yeah, it's the first of the month.
Judge, I don't object to you reviewing it. It appears to show a cash withdrawal occasionally of $300. It doesn't show who it goes to or what it was for.
She would only let me pay her in cash. Yeah, she made Jim pay in cash as well.
Hi, gambling.
You can continue.
Yes, quick summary. Easy. Lady on the right, her son and his wife, who was on the left, moved into her house. And then her son died. And now the widow is left in the house and not paying rent. So the mother wants the widow gone.
Your Honor, this case is not about a tenant dispute. It's about fairness, credibility, and the full story.
Oh, and the widow is countersuing for $5,000.
Excuse me. The plaintiff has brought this lawsuit claiming harm related to tenant issues, but the evidence will show that the plaintiff personally took $5,000 from the tenant's estate.
I thought they got married. That's my bad. Girlfriend. Okay, that makes it even worse.
The facts matter. It speaks directly to
Judge,
motive,
I'll object
credibility.
briefly. If the estate has an executor or administrative representative and wishes to bring a claim, it can do so. But the estate, Jim's estate, to the extent it is not represented, can't present a claim in this case. So I'd argue that the defendant in this case is not the proper party in interest to assert claim on behalf of the estate until that is addressed in probate court.
She took $5,000 from Jim's estate. Then she wanted to up my rent to $1,000. I live on Social Security. She knows exactly how much I make. There's no way I can live on $200 a month. She didn't get her way. Then she wanted the truck, which was my husband's. She's not getting the truck. So then we decided to do this. That's why she did it.
Okay.
I was willing to leave her half of $5,000.
So she said she was a widow at the beginning. I know that they said that they weren't married when they moved in. Maybe it's possible they got married afterwards, after they moved in together. Or maybe it's possible she just used the word widow because, you know.
As long as she left my butt alone. Because I wasn't doing anything except trying to grieve for my husband and get on with my life.
See, there she called him her husband, but she could just be saying that. You know what I mean?
She has no basis to evict me. Other than she didn't get her way. So this is how she decides she wants to try and screw people.
So what is your counterclaim for $5,000?
The money that she stole from my husband's estate.
Okay. And then, you allege that as of November was your last payment of your portion of the rent, correct?
Correct, because I sent her a text message stating that if she, wants to play games, then the $5,000 she took, she can use for my rent. Because the last time I checked, you can't evict people just because your butt hurt.
Gosh, there's so many things I want to say that would get me in so much trouble with this case.
And then, just so that I'm covering my bases, where was the $5,000 taken from?
My husband had a motorcycle, and he left it to me in the will.
And again, Judge, I'll object to any unprobated will being submitted.
There's the will. And here's her handwriting saying that I pay rent every month.
Judge, I'm going to object to a few things. One, this is not executed in accordance with Georgia's statute of last will and testaments, in that it appears to not be notarized. Further, it has not been probated.
It was probated. I took it to the probate court. Thank you.
Judge, I'll state in my place, there is no probate filing nor executor or executrix appointed.
Wait.
Hey, sorry.
And this is before they were even married, that's her maiden name.
Right.
And there's no date on it.
So, and to the extent Ms. Diamond is attempting to tender an unprobated, unproven will, there is a competing will which has also not been probated. Again, our position is that the estate, to the extent it even has a claim, this is not the proper forum. These are not the proper parties in interest until an executor has been named and appointed by the court and granted powers. And as it currently stands, that is not the case.
Objection. Her will has no standing because we're married.
But again, that's not going to come into play. Here.
All right. Anything else?
No.
Anything else from?
Brief cross-examination, if I could,
Yeah.
just to clarify a couple of things. The November text message that you had mentioned, where you had said she could offset the $5,000 against rent that was owed.
Mm-hmm.
Was any additional actual cash payment made during November?
I paid her the end of November. I'll show you. Because I usually pay her on the 1st, and I didn't pay her on the 1st. In October, I paid her on the 3rd.
Same
Hi,
objection, Judge.
Walter.
Yeah, co-buyer. Yeah, I'm not going to get into that. Well, we'll reserve for closing, Judge.
And I got, the only follow-up question that I have, because I realized I didn't get this. I assume the motorcycle was sold. Is that what was happened? The motorcycle was sold?
Yes.
And
Okay.
Judge, to the extent necessary, again, our position is that this claim is not right. May I approach?
Yeah.
This is the Cycle's bill of sale. Cycle bill of sale notes that Ms. Johnson was the co-owner of that motorcycle. If you look where it says co-buyer, she was a co-purchaser of that. It was not an estate asset of her son. It was a jointly owned asset.
Objection, she never made a payment. Jim made all the payments, and it was my money that went for the down payment.
And again, Judge, I don't think this is the proper forum, but to the extent the door's been open, we wanted to make that clarification.
Any other evidence from defendant?
I have pictures because She wants her rent money all the time, but she doesn't want to make repairs to the house. So apparently if it's gonna get fixed, I have to do it. And she's aware of all the stuff that's wrong with the house.
Okay.
And if it's our house, it won't get fixed unless it costs her money, like a water line, because it costs her money. She pays the water bill. If it's her house, it gets fixed immediately. If it's me and Jim's house, it gets rigged. Because the house is falling apart. It's up on a car jack for 2 years now. Because they didn't put cement so the house is sinking. So their solution was to put a car jack underneath the car, or underneath the house, which is pushing the floor up and wrecking the floor. And there's 3, 4, 5, 6, 7, 8, 9. There's a video about my dishwasher. And then I tried getting a picture of the car jack underneath the house, but it's right behind that pipe where that piece of wood is laying on the ground.
No objection to you seeing it, Judge.
But there's other pictures in there of all
Lawyer's like, yeah, go ahead, show it. It's fine. You're still gonna have to leave, lady.
the stuff that's wrong with the house that she's known about and refuses to fix it. Like the pipes aren't even connected, so, you know, we had to stick a wood block under there to hold the pipes up in the kitchen so it wouldn't leak all over my kitchen.
And just so I'm covering my bases, when did you start asking for repairs?
We asked for repairs all the time and we got ignored. This is a picture of the floor coming off the house. The floor is separating from the walls in the house.
And to the extent of what it shows, Judge, no objection.
Okay. All right. Anything else from defendant?
My doors are splitting in half too. Like that, you know, she's aware of it. She sees it. She's been over enough. No. But we get treated like second-rate citizens. Because if it's her house, it gets fixed immediately. If it's our house, it does not. Unless it costs her money.
Okay.
You know, like a water pipe or something. You know, pipes leaking in my house is not gonna, you know, cost her money. My dishwasher not working, don't cost her money. The house falling down doesn't cost her money.
Okay. Anything else?
Enough.
All right.
I mean, my dryer broke and I had to pay for that myself too.
All right. Close.
Briefly, Judge, and while there are clearly issues surrounding these parties, I think for purposes of today's hearing, the tenancy at will guidelines have been followed. A 60-day notice was given. There's evidence that it was received. There's evidence that the address was active, in that the signature for the green card did show up on the second notice. The posting notices required for the Safe at Home Act, and she's not surrendered. Whether rent was paid during the time during which that occupancy was winding down is not relevant to the question of possession. So our position remains that rent would have been owing since approximately August of 2025. To the extent the court finds differently, I don't think that changes the outcome on the question of possession. As to the question of the tenant's damages, there seem to be two types alleged. One seems to be a claim potentially on behalf of the estate. I would argue that she is not the proper party in interest until or unless she becomes the executrix of the estate. As to any of the other repair type damages, there's been No evidence submitted of the financial cost or damage to this specific tenant. If there is damage to the property itself, that is damage to my client's property, not to the tenant. And to the extent the tenant wants to make a constructive eviction or deduct and repair argument, she has not demonstrated compliance with those guidelines as far as providing notice and then notice of deduct and repair and then the cost of those repairs. And absent that, I would ask that you issue a ruling in favor of the landlord, issue a writ of possession for the property located at 55 Pirates Point, Dawsonville, Georgia. And then I would ask that you include a judgment for rent arrearage in the amount of $4,200. I would also ask that in the event of any appeal, the amount of rent be directed to be paid into court at the time of the appeal, and that in the event of any appeal, rent shall be assessed at the amount of $600 a month to be paid into the registry of court during the ongoing pendency of any appeal.
That was $4,200?
$4,200, correct. Thank you, Judge.
All right. Court will find in favor of plaintiff. Total amount of reward will be $4,200 plus court costs. And defendant's counterclaim, or in a judgment for plaintiff on defendant's counterclaim.
How many days does she have? Did he say? Did I miss it?
You will have. Yes.
I'm sorry, go ahead, Judge.
I was just going to say, I'm going to send the order. It is stayed for 7 days under Georgia law to allow you time to decide if you want to provide an appeal to Superior Court or anything like that. Just understand that, yes, all monies that are currently in arrears would need to be paid into the court, and monthly rent would need to be paid into the court in order to satisfy that appeal. Okay. Your appeal will be filed down in Superior Court, Clerk of Court's office, all the way over to the left off the elevator. Okay. Assuming that you don't file an appeal, again, 7 days. So on day 8, she's entitled to a writ of possession and can proceed with set out. Okay.
7 days to move out. 7 days.
Was there anything I didn't cover?
Oh, sorry. In the event of an appeal, the $600 a month being paid to the registry.
Yes.
Thank you.
I don't think she understood anything the judge just said.
Mm-hmm.
It doesn't sound like there were any children in the marriage, though. So that's good. If I had to move in 7 days, I know where I would go. But man, it would be hard. There's no insects. There's none. No insects. that would be a hard stop for me. I narrowed it down to what happened. I narrowed it down to what is causing it. And believe it or not, I think what's causing it is something I've used a million times before. And just all of a sudden now I can't use that anymore.
It's okay. We'll get it figured out.
How long for what? I missed something. Oh yeah, she has 7 days to move out. She has 7 days to get out of her apartment. This lady on the court case.
All right, so we're having some technical difficulties getting
Ow,
our current work.
I'm leaving. I'm
I assume we can
me.
email you a copy. We have that on file for you, I believe, correct?
We should, Judge. I don't know, we hand filed this one. It may not be on file. Here, I've got a card. This one I think was actually hand filed.
Almost a year.
Thanks.
Yeah, just if you have a card, we'll be fine.
And I'll also accept service from my client. I'll pass that along as soon as that comes in.
Perfect, sounds good. And then, see if we can get something working.
My daughter's high school. He's first junior. 11th grade.
Granddaughter's a sophomore. She's in the band.
Okay. My daughter. These days.
She would have to appeal, she has to pay all of that money to the court first. Like $4,000 plus court costs in the next 7 days.
Mr. Bagwell, you and your client can go ahead and go. We'll email you copies, and then
Thank you, Judge.
I'm going to get that in just a second and sign it, and then I can provide a physical copy.
Thank you, Judge. Have a good rest of the day.
Thank you.
Thank you, Judge.
Yes, ma'am. All right. So if you will just go back to the first row back there, when she comes back in and I sign it, you'll get a copy of the order ready to go, okay?
Yep.
I don't have life insurance. So it wouldn't be good killing me.
All right. Let's see. Last but certainly not least,
Here we go, guys. One more.
And
Oof.
Morgan Peterson,
Oof.
Christina Brown.
Oof. Did I say
Yasmia
oof about
Cochran.
this next one? Oof.
Why do you always make me go last?
I don't know. It just always works that way.
At a certain point in the first one, I was hoping to be run over by a diminished value car.
I was too.
You have extremely more patience than I do.
That's what my clerks say all the time. That is what my clerks say all the time. All right, let's see here. So who do I have at the table?
Morgan.
Morgan.
Here we go.
Cochran.
Cochran. Okay, perfect. And then Miss Brown.
She's right there.
Okay.
We can, sure.
Yeah, sorry. We can pull up another chair for you. You're good. All right, perfect. All right, so this is a dispossessory regarding 682 Summerwood Lane.
That's correct, Your Honor.
Go ahead and give me an open.
Yes, Your Honor. This is a dispossessory for unpaid rent of now 4 months. Notice was given January 14th, posted to the door. I believe in this case, we only have an answer from one defendant in which she admitted to she does not dispute the reason for the eviction. I believe nothing is in contest here today.
His name is my adorable judge. This is the adorable judge. I don't know his name.
Go ahead with case in chief
But if Kelly was here, she would find it. Kelly, I hope you're okay.
for me.
Your Honor, yes, this is pursuant to a lease agreement with a monthly rent of $2,500. Rent has not been paid for November, December, January, and February. There was also a partial payment that was due of October's rent. At this point, we are asking for past due rent at the time of the filing was $7,870. There's been an additional month's rent of February of $2,500 added on to that. That is $10,370. We are also asking for attorney's fees of $1,500 pursuant to the lease agreement, plus court costs of $210. We're asking that for a writ of possession or pay rent or a writ of possession within 7 days.
Sorry, total amount again for the principal?
Total, hold on, let me add. $10,370 for rent, past due rent, $1,500 for attorney's fees, and $210 for court costs.
All right.
I bet you they have bidets.
See, here's what we're gonna do. All three over here, if you will please raise your right hand for me, please. Do you swear the firm testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God? Okay. Go ahead and tell your side of the story, what's going on, and we'll talk about it, right?
Do you want to talk?
You can sit down. You don't have to say
Okay,
that.
gotcha. I don't object to anything that was stated.
Right.
The only thing that we're asking for here is possibly more time to help find a place to live. So that's really all that I have to say.
Understand. And I assume nothing else from either anybody else?
Well, my biggest concern is for my grandchildren that I raise. I'm raising, we have to have a place to live. And I'm not saying we don't owe it. Lord knows I'm not saying that.
Okay.
Because we do. But I don't have that much money just to,
Right, understand.
I'm on retirement and get a check from the state taking care of my son, my boys. Till they're 18, but they've already shipped up to them. Or I do now, my husband passed away.
Okay.
And right now, they're so up in limbo.
Okay. Understand.
Till their grades are dropping in school.
And it was
Wait, did you just say your rent amount, Bren, because it didn't show up? Oh no, you just said I pay more than that, more than $2,500 a month. That's crazy.
so the boys live with you two. They're just minors. Is that correct?
Yes.
And then you two are of age.
We are, this is my granddaughter, this is my significant other.
Okay, gotcha. Understand. Perfect.
I've raised grandchildren since whenever, These are my great grandchildren here.
Understand. I gotcha. Okay.
She's taking care of all of her great grandchildren.
All right. So from the outset, I mean, just to be completely abundantly clear and honest, my hands are very, very, very tied when it comes to non-payment of rent. Okay. Just as an outset, if we don't come up to some sort of agreement that we can reach between the parties, and I'm not saying that plaintiff will even entertain anything at this particular point in time, but just so that you understand where we are, the max that I can give is 7 days. Okay, that is the absolute maximum by law that I can give. It would be a judgment for the total amount plus court costs, and then you have 7 days to figure out what's going to happen. And on day 8, a writ can be gotten. Now, obviously, on day 8, it's not going to be necessarily served, especially if they go through the sheriff's office. It'll be a couple of extra days. But once the sheriff comes and they say time to go, it's time to go. Okay, so 7 days is always a really good kind of rule of thumb there. I can't do anything beyond 7 days without there being a consent judgment between plaintiff and the 3 of you. Okay. The only way that I have ever really worked to be able to have any sort of consent judgment in a situation like this, especially with the amount in arrears, is a significant sort of payment plan that we can set up, and then there's there's a date certain to be out, and then there's a payment plan for the collection of the debt, so that no additional fees or costs or anything else like that is incurred by the plaintiff. Okay, is that something that your client is open to?
Your Honor, the problem's been is that, this is month 4 that they haven't paid any rent. It's not like they haven't seen this coming.
I understand.
Answer the question.
I mean, we would ask that the writ be issued in 7 days, and I understand the process on getting the marshals to come out there. I don't know how quickly Dawson County is doing it, but I think there's a little bit of time after that.
Oh yeah, yeah.
I think it's actually probably at least 2 weeks. So I mean, we would probably be looking at least 3 weeks from today before it could even be served or affected. So
That lawyer just lied in court, and the judge just let him.
I mean, obviously, with that understanding, 3 weeks is better than 7 days. So I mean, I don't feel like there's going to be much more that I can get over here. Obviously, okay. So my ruling is going to be a judgment for the full amount. It'll be $10,370 in past due rent, $1,500 in attorney's fees, $210 in court costs. Okay. 7 days. Okay. Obviously, like I said, if it takes a little bit longer to get served, it takes a little bit longer to get served. But I would just work towards looking for somewhere else. Okay. We'll provide you with a list of community resources that we know of and have, so that you can at least have some sort of guidance there. But other than that, that's about all we got. Okay. Once I get this order signed, I'll give you a copy of it, and then y'all are good to go. Okay. Okay. You just want an email?
yeah, that's fine.
All right.
All right, thank you, Your Honor.
Thank you.
Thank you.
I don't know how many kids live with her, but I think it's more than just those 2. Those are her great-grandkids. So she probably has the grandkids live there, too. I don't know where the parents are. She's the great-grandmother. But now they have 7 days. Well, guys, we made it through. Hi, another Smith. We made it through the adorable judge. I do love that judge. All right, we're good. Thank you so much for coming out. I appreciate it today. I'm glad I didn't take the day off. I'm glad we did the stream anyway. And I'm glad you made it back, Bobby, today and from your coffee run. Both. Micah, it was so good to see you. Alright. Today's Friday, guys. We made it to the weekend almost. Get through today. I shall see you all tomorrow morning. I hope you guys have a nice, easy day. Alright? Bye, guys. Thanks.
chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see